Okay, welcome everybody. It's very nice to see you all here. My name is Maria Lee and I'm a Professor of Law here at UCL, and I am co-convener and co-editor of our Current Legal Problems lecture series and publication. And we've been holding these lectures since 1948. So it's a real privilege to have this role for now. And my job today is simply to welcome you all to UCL Laws, and also to introduce our wonderful chair, Professor Rosemary of Auchmuty. Rosemary is Emeritus Professor of Law at the University of Reading, and she is a pioneer of women's studies and feminist legal studies. Her publications, her achievements are manifold and multiple, and most of you are familiar with them. All I will add today is that she's made an extraordinary contribution to the entire discipline, not just to women's studies, through her scholarship and through her service. And I am delighted to have Professor Sharon Thompson here from Cardiff for her lecture on the inconspicuous impact of feminist pressure through law, and I'm delighted to hand over to Rosemary. Thanks very much.
Well, thank you, Maria. And obviously, I'm delighted to have been asked to chair this, and I'm delighted to introduce Sharon Thompson. I was going to start actually by saying how I met her and basking in the reflected glory of the fact that I introduced her to, I think, the fascination of feminist legal history. But she's going to do that, so that's fine. We'll spare that account. I'm just going to say that from that start, when she put some really useful history into her first and wonderful book, this one here, which was based on her PhD, she has published a really excellent volume of work in feminist legal history, as well as other subjects. And of the many projects that she's been involved with, some with me, some with Erica, some with other people, and of course she's instigated her own projects. She's also written individual works, and of them, I just want to mention the second book, Quiet Revolutionaries, because it's such an interesting piece in terms of feminist legal history. It's what you would expect, a fascinating and rigorous history of an association, little known association, the Ordinary Women's Association, which flourished in sort of mid-century Britain, mid-20th century Britain. But it's more than that, because she did two things which I think were completely original and really brought home, I think, to me, the development of the discipline of feminist legal history. First, she established this association, which has generally been forgotten or ignored or misrepresented when it is mentioned. She established it as a feminist organisation, even though both the divorce law reformers and people like myself, second-wave feminists, thought they were just conservatives, actually reactionary. And she's made it very clear they're feminists. And secondly, she's made it clear that this is a book of legal history. She's writing about a women's organisation that actually, for all it campaigned and lobbied for law, for legal change, actually didn't get very many of the things that lobbied for, and it took a very long time for them to get who they did. Okay, that this is a part of legal history because it's an account which actually says, let's look beyond the courts and the judges and the responsiveness to changing social attitudes and look at what actually was happening, sometimes for decades or even longer, which was women mobilizing to try and change the law for women. So that makes this a particularly original work. It's also innovative in the methodology that she uses, and I know for lots of younger scholars, methodology is a bit of a worry. I think it's worth reading just to see how lightly that can be worn. It doesn't have to be punched into your face, and actually what a really interesting read it is. And so I was really delighted when Sharon showed me the paper that she is going to give to you today, and I realised it was in feminist legal history. It's very dear to my heart. And so I'll give you Sharon Thompson.
Thank you so much for your introduction, Rosemary, and thank you for chairing today. And of course, thank you so much for all your help and support over the years. Thanks also to Maria Lee and to the other Current Legal Problems editors for having me speak today. And thanks also to Russell Sandberg and Erica Rackley for their help in the preparation of this lecture. I'm delighted to be here, and I'm really grateful to you all for coming here on your lunch hour or for tuning in online. So to begin, I want to go all the way back to my time as a law student at Queen's University, Belfast. And my sense throughout my law degree was that women were mostly subjects, not agents of law, that they had contributed little of value to reforming the law. And my understanding was the law is what judges say it is. And of course, these judges were almost always lords and lord justices. And to me, Lady Hale was a sort of unicorn almost, because she was on the front lines of law reform, both in the Law Commission and later as president of the Supreme Court. So it seemed grim to me that the law seemed to be mostly applied and made by men. And this appeared especially to be so in my home country of Northern Ireland. After all, it was only in 2015, 6 years after I'd completed my law degree, that Justice Keenan and Justice McBride became the first woman to be appointed as High Court judges in Northern Ireland. So to me, law reform certainly did not seem to be a feminist or even female accomplishment. Then, at the very start of my PhD viva, my external examiner, Rosemary Auchmuty, thrillingly shattered this rather depressing illusion. So to quote from her external examiner's report, you could usefully take note of the feminist activism which predated the second wave, but demonstrated that the women's movement never fully disappeared after the granting of the vote. This is documented in Dorothy Stetson, A Woman's Issue, but it's been routinely ignored by English legal historians because of legal scholars' unfortunate tendency only to read insider legal accounts. This tends to produce a tale as divorced from context as the judgments in your cases. So thanks to Rosemary, feminists I then discovered were far from simply being long-term implacable opponents of the law. They were also activists interested in using the law as a means of change. Of course, whether they succeeded in doing so is another question entirely. Indeed, determining how feminist activism has impacted the law is complex, not least because impact itself is an elusive term. Formal changes in the law result directly from precedent, and thus from pronouncements made by judges, or law commission recommendations taken forward by government, or from political policies translated into acts of parliament. Intentionally or not, we are therefore attuned to a particular narrative of what it means to influence law reform. We tend to view law reformers as those responsible for transforming the law, those for whom we can say, but for their involvement, the law would not have changed as it has. Academic lawyers are trained in the rules of causation, and we look, of course, for evidence and links between conduct and effect. But this is not the whole story. Impact and influence are also informal, and this was brought to the fore when the Garrett Club, an almost 200-year-old elite private members club, was pressurised into admitting women earlier this year. 60 members, including several judges, had been named and shamed in The Guardian. And here is a petition from 2022 calling for the Garrett Club to admit women because failing to do so was, quote, contributing to the gross underrepresentation of women at the top of the legal profession. And when Lady Hale, then a Supreme Court judge, criticised the club in 2011, she too argued that these networks had a detrimental impact upon judicial diversity. The exclusion of women from such powerful networks mattered. Still, it took nearly 13 years following Lady Hale's remarks for change to happen. For, as she astutely noted at the time, her colleagues simply did not see what all the fuss was about. So while elusive and difficult to pin down, elite male-only spaces can influence law and policy. But when it is not seen as a problem by those in power, it can be extremely difficult to achieve direct impact. On the other hand, Lady Hale's observations were important, where they lay the groundwork for future reform. Attitudes did not change in isolation, and this pressure mattered. If we only have a limited formal understanding of what it means to influence law reform, we risk discarding as too remote campaigns which were in fact very important. Indeed, so many interventions that may not have been immediately or directly successful had nonetheless what I term inconspicuous impact on law and law reform. So I define inconspicuous impact as an effect upon the law that ultimately leads to change, but not in a linear or short-term fashion. The effect is inconspicuous because it relates to efforts to change the law that are not typically viewed or credited as having contributed to law reform, perhaps because those efforts were initially or ostensibly unsuccessful. The inconspicuousness of impact is especially characteristic of feminist efforts to reform the law through legal channels, since historically feminists have struggled to gain a sympathetic ear among members of the executive or the judiciary. And this has often left feminist pressure groups outside of formal lawmaking processes, but they've nevertheless been lawmakers in an indirect sense. So in this context, I refer to feminism as a perspective that brings to the fore gendered power and women's subordination within law. Building on Carol Harlow and Richard Rawlings' work on pressure through law, feminist pressure through law is the collective use of law and legal mechanisms by women and men to dismantle aspects of the law that perpetuate gendered inequality of power. In this lecture, then, I argue why and how we should pay attention to the more subtle ways in which feminists have contributed to law's development. There's a need not only to recognise the inconspicuous impact of feminist pressure groups, but also inconspicuous impact can be used as a tool to reevaluate the very mechanisms of law and its reform. The extent to which feminists have contributed to law reform is, of course, difficult to trace. When an act is introduced, to what extent can we say that feminist campaigners deserve the credit and that change would have happened regardless of their efforts? Conclusive evidence that a test case or lobbying activity or a failed private member's bill, for example, moved the needle towards reform is very hard to prove and is perhaps unknowable. This gap in knowing can be acutely uncomfortable for legal scholars, acclimatized to operating within the boundaries of law's provable certainties. It is therefore much easier for textbook accounts of law reform to imply that reform improving the legal status of women has occurred simply as part of a process of modernisation. Gathering the evidence to prove otherwise is an inevitably spurious task. So how then do we determine the impact of feminist pressure through law? Well, this has been attempted by the American historian Dorothy Stetson, whose work was mentioned by Rosemary in my PhD Viva, and it exposed the stories of law's inexorable modernisation as myth. So she put textbook accounts to the test by measuring the impact of feminist campaigners on family law from 1857 to 1970, using a method that bordered on the scientific. For Stetson, feminist individuals, groups, or their representatives had to be identifiable within pivotal moments when decisions were ultimately taken about whether reform would be taken forward. They had to be present at the time the reform was occurring, whether that was in legislative spaces such as parliamentary committees, administrative spaces such as law reform bodies, including the Law Commission, or coalitions of policymakers. Direct participation was key. Then Stetson assessed the congruence between feminist demands and actual policy. So this meant that if feminist demands were not taken forward, their campaigns did not register on Stetson's barometer of impact. Nevertheless, her uncovering of feminist influence upon law was remarkable. She broke new ground by developing a methodology for tracing feminist impact. So although I argue for an approach that differs from that developed by Dorothy Stetson to make visible feminist impact through law, I am really indebted to her work. And I seek not to dismiss it, but to build upon it and to push for a more broader and nuanced conception of what counts as impact. Because Stetson focuses upon crucial moments in feminist activism, where demands are reflected in law reform and where feminists are present in these institutional spaces, and at these crucial moments. She is highlighting conspicuous impact. And even if this impact has been ignored in textbook accounts, it is conspicuous because it fits the mold of what lawyers would consider to be a successful campaign, one that has impacted law reform in a demonstrable and immediate manner. But that's not my focus today. I'm interested in inconspicuous impact. So in other words, the impact that isn't credited as having contributed to reform, because I think that pushes us in a broader, more contextual understanding of law's evolution. So I now want to explore a little further why so often efforts to reform the law are inconspicuous. And I'm going to do this by drawing upon my work on the Married Women's Association, which, as Rosemary has said already, is a group that sought from 1938 to the late 1980s to transform women's status in marriage so that a wife could be the equal of her husband in law. And the association was a single-issue pressure group that predominantly used law as an instrument of change, drafting bills and funding cases in court. But the group is not credited as having contributed to the shape of family law in the 20th century. Quite the opposite, its work is now virtually unheard of. But first, it's important to understand how the law affected women in the 1930s and 40s. Women, of course, were either married, potentially married, or had formerly been married. And they weren't expected to support the family as breadwinners, so they were paid much less. And in some professions, being married would mean that they wouldn't have a job at all because women were fired. The fight for equal pay needed to rail against a deeply entrenched idea that women simply didn't need as much money as men. But asserting that women didn't need money as men did was to ignore the practical and social realities of women's poverty. Even though women tended to be responsible for managing the household expenses, the money used to purchase groceries, furniture, clothes, and everything necessary for family life belonged to the husband if the money came from him, from his income. Women were administrators without legal power and with no right or recourse to know the details of their husband's earnings. An everyday reality for deserted wives was therefore financial destitution. And this motivated the campaigns of the Married Women's Association to focus upon married women's property rights during the marriage and on relationship breakdown. And against this backdrop, a really interesting idea began to emerge amongst post-suffrage feminists, and that idea was of wages for wives. So here you can see an advertisement for an American silent film of that name, and the plot centres on a group of women who leave their husbands until they agree to a 50-50 split of their wages. Comedy, of course, ensues as the husbands refuse their demands and cause chaos trying to do the housework and other domestic chores themselves. The broader point, however, is one that continues to resonate today, that caregiving and domestic work has value and should be recognised in economic terms instead of being unpaid. Of course, at the time, it was seen as absurd that women would be paid for doing the housework, which leads me to the first reason why feminist pressure through law can be inconspicuous. It's because it often raises the unthinkable. So throughout history, feminist campaigns to reform the law have been rejected by Lord Chancellors, MPs, and successive governments because the demand is viewed as too controversial or even outrageous. Or, more simply, it's often because the demand is not seen as being a problem in the first place. When these ideas are dismissed, they are not viewed as having influenced reform, and so pragmatic approaches to reform are often considered to be more effective. Yet demands that were unthinkable to those in power at the time can nevertheless be impactful, laying the groundwork for more subtle shifts over time. So Wages for Wives was more than a 1920s American film. It was a provocative, radical demand made by the Married Women's Association in the early days of the group. It was subversive and disruptive, especially in the context of the late 30s and early 40s. Housework was, they said, not a woman's duty to be exchanged in return for a wedding ring. It was real work. The housewife was not an invisible and unemployed citizen. She was a member of the working population, deserving of recognition by the labour movement. Her work was highly skilled, arduous, and had social value. So the idea of wages for wives was much too radical to influence law reform in a direct sense. It was never taken seriously by those in power. But the idea was influential in a more inconspicuous way because it was controversial. Insisting that women's work in the home had economic value transgressed the boundaries of the public-private divide. Demanding hard cash for housewives would have revolutionised the management and ownership of capital during marriage, while giving economic power to otherwise disempowered married women. To assert this more strongly, the group attempted to set up a trade union for housewives. This so-called housewives' union failed to obtain trade union recognition several times, but even so, as an unofficial union, housewives in a legally precarious position could connect with others in a similar position requiring help and support. So this new way of thinking about domestic work had inconspicuous impact because it changed how women sought to use and challenge the law for their own benefit. The Housewives' Union boasted the legal recognition of housewives, and if women could be encouraged to view themselves as joint treasurers and equal partners in the family income, they could effect change. For in being aware of the legal ramifications of marriage, married women would be better equipped to challenge it. From this perspective, feminist pressure through law can be a form of protest. As former suffragette and vice president of the Married Women's Association, Teresa Billington-Gregg, put it, "Wages for Wives" was the first slogan of the Married Women's Association, coined by the press and much disliked by an increasing number of supporters. And it actually caused quite a lot of disagreement within the Married Women's Association itself, because a sizable portion of the group viewed the husband's payment of a wage to his wife as only exacerbating her subservience. But that's a whole other digression. As Teresa Billington-Gregg said, "Personally, I think it did more good than harm. It emphasised that in a world full of wage workers, there was one enormous section of workers who got no wages for all. The taken for granted habit became a matter for question." So I would suggest this is how impact can be inconspicuous. We often don't credit pressure that causes the taken for granted to become a matter for question. But this is vital in getting issues on the reform agenda. Paradoxically, ideas considered to be controversial or unthinkable can also produce visible, effective propaganda, where prudent reform might be more narrowly constrained in the issues it addresses. So just because a demand is unthinkable when it's made doesn't stop it from creating change in more subtle, indirect ways. And identifying this impact simply requires changing the lens through which we identify influences upon law and policy. The second way in which feminist pressure through law can be inconspicuous is that it can be untimely and non-linear. And this is because tracing the impact of feminist pressure through law also requires taking a zoomed out view of legal development, instead of focusing upon whether the campaign was successful in impacting law at that moment in time. Exploring feminist impact across time contrasts with the temporality imposed upon feminist campaigners and the women's movement by historically misleading descriptions such as first wave and second wave. Indeed, the familiar metaphor of the feminist waves has powerfully obscured histories of women's attempts to reform the law. For example, the 1940s and 50s has often been characterised as a period of decline in the women's movement. But the work of the Married Women's Association is one notable challenge to this view of the women's movement. The group's early policy of wages for wives and later campaigns for women's work to generate economic value in the family assets are seldom connected and often disassociated from feminists of the second wave. Yet in the 1970s, the concept of wages for housework re-emerged as a key demand of the women's liberation movement. This was considered new and revolutionary at the time, even though it had been campaigned for by the Married Women's Association in the early 40s, and the concept even featured in earlier campaigns from the 19th century. While the underpinning feminist ideology differed across time, in that the 1970s campaign was based upon Marxist ideology and called for housework to be abandoned entirely, the disconnect between the second wave and the work of post-war feminist groups shows how categorization within feminist history can contribute to the relative invisibility of the Married Women's Association and the inconspicuousness of their work. This can mean that the origins of ideas that ultimately influence law reform are inaccurately attributed to those directly responsible for the reform or to those who most recently verbalized those ideas. Indeed, feminist demands to reform the law are often influenced by historical campaigns, and the continuity of demands to reform the law can only be traced by recognizing the inconspicuous impact of so many overlooked activist efforts. As well as making visible then the continuity of feminist networks, emphasizing the untimeliness of feminist work enables us to look differently at the strategies used to effect change. So taking this approach helps us to reevaluate the importance of, for example, the Married Women's Association, which certainly was untimely in its impact, but other groups as well. Their calls to extend married women's property rights to reflect marriage as an equal legal and economic partnership were consistently rejected. Yet aspects of the Married Women's Association's demands later re-emerged alongside debates about financial provision for married women in the late 1960s and early 1970s. And while the group's proposals might have been radical in the 1940s, by the 1970s, some of these proposals were more viable when the question of married women's property rights was brought to the surface alongside reform of divorce. For example, discussions over the Married Women's Association's policy of joint ownership in the home influenced MP Edward Bishop before he introduced the Matrimonial Property Bill in 1969, which played a key role in pushing the government towards agreeing to reform the financial consequences of divorce in 1970. Another reason why impact upon the law might be inconspicuous is that it can arise from failure. One of the Married Women's Association's strategies to assert pressure through law was in the courtroom, funding cases and pooling legal expertise within that group to assist women. Of course, a successful case can lead to direct impact. It can shape the common law and draw attention to the need for further reform. But failure has its own power. When Mrs. Dorothy Blackwell, here on the slide, lost her case against her husband, which was funded and supported by the Married Women's Association, it was, of course, an ostensible failure. Yet it became one of the association's richest sources of propaganda. For a failed case does not always point to flaws in the campaign, it can expose flaws in the very fabric of the law. When Dorothy Blackwell left her husband, he took her to court for her entire savings. He claimed this money was legally his because it comprised of savings from housekeeping money that he'd given his wife to buy groceries and other household goods. She owned nothing, and when her husband took her to court, the judge ordered her to hand over all of the £103 she had saved. In taking on Dorothy Blackwell's case, the Married Women's Association had a concrete example of how the law was letting women down in the 1940s. So the group was unsuccessful in changing law inside the courtroom, but by making Dorothy Blackwell the relatable face of their reform campaign, the group could effectively translate a collective sense of discontentment into support for its policies. 20 years later, this campaign culminated in the Married Women's Property Act 1964, which gave wives a legal right to a half share in housekeeping money. Significantly, this act was the first time that such work could be legally recognised as having economic value. But the feminist activism behind this reform is not acknowledged in contemporary accounts of the act. So to recognise the inconspicuous impact of her case and the Married Women's Association's connected campaign, we must alter our view of what counts as law reform, what counts as success, and why the case was lost. An argument ineffectively prosecuted in the courtroom may not be redundant, but may instead be constrained by precedent and the parameters of existing legislation. It may be that this argument illuminates the shortcomings of the law, and perhaps it is the failed case more than the successful one that highlights the need for legislative change. Finally, a fourth reason why impact may be inconspicuous is that it can be uncredited. As we've seen, there's so many examples where the Married Women's Association indirectly influenced reform but weren't credited for it. And these omissions show that accounts of how legal reform happened can be skewed, helping us to understand how the Married Women's Association's story has been virtually obliterated from histories of family law. But there are thousands of other stories just like these forgotten campaigns. And so a more complicated question than whether such campaigns are uncredited is why. One reason might be that feminists didn't care about getting the credit. They just wanted to see the reform through. When asked about this in 1975 by historian Brian Harrison, the Married Women's Association chair, Juanita Francis, said, well, any person or organisation are just cogs in a wheel. We do what we can, but it doesn't rest on us if we go under and somebody else will come along. Like other members of the Married Women's Association, Francis knew her feminist history and that the influence of women's collective action often did go uncredited. Another reason, though, that this work is that this work is obscured from contemporaneous accounts. Even if we widen the net as to what counts as law reform, we can't go back in time and change the purview of legal academics from the past. So when royal commissions or law commissions or Lord Chancellors or members of Parliament and others directly responsible for implementing policy are solely credited with reform in the textbooks and articles of the time, our understanding of how law is reformed is incomplete. But if we as academics accept these contemporaneous sources as authoritative and exhaustive accounts of reform, then the work of feminist campaigners is made even more inconspicuous. So far, this lecture has explored why the impact might be rendered inconspicuous. However, arguing that the work of campaigners has been overlooked is not in itself reason for legal historians to revise histories of law reform. So as a result, I now want to turn to why such revision is vital. Recognition of inconspicuous impact matters. It demonstrates that direct impact may not be the only effective impact, and it reveals law's potential as a mechanism for feminist reform. That indirect impact can be as effective as direct impact is on its face a paradoxical claim. It's obviously better for feminist campaigners to have legislation taken forward that they had a direct role in drafting. But much can be lost in the process of translating feminist demands into legal policy. And when feminist aims are directly implemented, those in power might use that as a reason to refuse more fundamental change. So indirect impact, which is often uncredited and rendered inconspicuous, can be influential in different ways. While it might not always be possible to point to a statute as proof of impact, inconspicuous influence has the potential over time to shift the Overton window towards a position more favourable to women's interests under the law. But this impact is often long-term, and therefore it's more difficult to ascertain. But we should not be blind to it. The scientific concept of change blindness can help expose why histories of law often entirely neglect the impact of feminist pressure through law. Change blindness is based on the psychological finding that the visual changes become very difficult to detect when the viewer is focusing on something else. And when that change is subsequently pointed out, it can seem obvious to an almost disorientating degree. Change blindness has been used to show why eyewitness testimony so often can be an unreliable form of evidence, and it's proof that sometimes things are not as they appear. Now, this magic trick animation was created by the Science of Magic Association, but it's based on a magic trick that can be traced back to 1909. So we've got 4 cards on the slide, as you can see. They're going to turn over briefly in a second. So I would like everyone in the room and everyone online as well to just select one of these cards when they appear and hold it in your mind, but don't tell anyone else. Now, think very hard about the card you've selected. Visualize it as best you can and hold that card in your mind. So as you can see, there's now 3 cards left. 1 card is gone. Now, was it your card that disappeared? Yeah. So because you were focusing on your card, some of you might not have noticed that all of the cards differed from the original 4 shown on the slide. And this card trick is what illustrates the phenomenon of change blindness, which, as I said, magicians have relied upon since the early 20th century, and it was then given the label change blindness by these psychologists in the 1990s. And I think an analogy can be drawn between change blindness and perceptions of law reform. And one example of this is being blind to the shifts that enabled, for instance, women's non-financial contributions to be recognised in family law. Erica Rackley and Rosemary Auchmuty tell us that historians are wrong to attribute reform like this to changing attitudes because feminists had a role in achieving that change. But this is difficult to do if we do not recognise inconspicuous impact and view, for example, the Married Women's Association's failed attempts to have unpaid domestic work valued as part of reform processes. So my point is that if we focus narrowly on legislation and other direct forms of impact, we are then blind to this change and we're blind to reform. And as a result, this causes a problem that I call reform blindness. So reform blindness is a way of understanding inconspicuous impact. If we are blind to the subtle sort of subterranean shifts that might not be considered reform, but do in fact change perceptions of law and the issues law regulates, then we are never going to recognise the indirect impact driving such change. Now, the second reason why inconspicuous impact matters, well, law's potential as a mechanism for feminist reform can be revealed when success and impact are redefined. Feminist networks, ostensibly unsuccessful reform, can be stepping stones to realising their bigger goals. Inconspicuous impact is one way of understanding how feminists have pursued strategies that in fact are effective but are not recognised as such. While Parliament routinely seeks the views of lawyers, women historically have had to push their agenda from the margins, often with few political resources. Feminists have learned this in their attempts to assert pressure through law to pursue the piecemeal, pragmatic reform over the all-encompassing change, and to work with historically conservative legal practices instead of against them. Still, since legal processes aren't inherently feminist, of course, it follows that feminists tend not to have much power to influence the law. Yet, even though feminist campaigners have historically been outsiders to lawmaking, ironically, this can be how feminist ideas derive a very particular sort of power. That is, in searching for inconspicuous impact, it allows us to reevaluate how law deals with ideas outside of its domain, in turn enabling law itself to be understood differently. From this perspective, inconspicuous impact can be a useful tool. It can help us to take a step outside law's understanding of impact to unmask law's marginalisation and neutralisation of non-legal ideas. An awareness of this can also inform how we view law reform. In other words, inconspicuous impact can be used to translate extra-legal ideas and their importance for law, revealing a more nuanced and complex interplay that would otherwise be lost. So, to conclude, I would encourage everyone to follow the story of the controversial campaign or the demands that fell on deaf ears at the time that they were first uttered, or the piecemeal, ostensibly trivial statute or provision, because this can inspire new insights into law reform. We can discover that inconspicuous impact can be an effective means of reforming law by stealth, that we should not be blind to unsuccessful reform because it helped later reform to happen. And moreover, reappraising events that were not considered important at the time can lead to the reframing of current legal problems too. We are likely to come to the disorientating realization that much of what we thought was new originated in reform campaigns many years ago. Of course, the problem with inconspicuous impact is that it is harder to spot and credit. After all, impact is an elusive concept, and feminist impact even more so. But we can start by challenging institutionalized ideas of what impact means, drawing upon a broader range of non-legal sources to inform our work and taking a long view of law's evolution that debunks myths of modernization and progress. By delineating a subset of feminist work and defining it as inconspicuous, we can continue the work of other feminist scholars in finding and resituating the forgotten and neglected voices of law reform. While most of this talk, of course, has argued why we should acknowledge the inconspicuous impact of feminist pressure through law, I want to end by turning this assertion on its head. What happens when we do not do so? When impact is defined narrowly, this contributes to the disappearance of feminist work throughout history. So unless it's revised and reassessed, the silence about this work in contemporaneous accounts is echoed in our own scholarship. Consequently, our research is tainted by omissions at best and accuracy at worst, and it risks becoming, to return to Rosemary Auchmuty's words in my PhD Viva report, a tale as divorced from context as the judgments in your cases. Thank you.